Hello, YouTube. I'm Vince White. I'm an employment attorney. And on this channel, we are answering live questions for an employment attorney. Got a question here from This Unusual World, which is a great username, who asks us, "Hi, Vincent. Your videos have been so helpful. A lawyer told me he wouldn't take my case because there's too much time between my protected activity and my retaliatory event, and that he doesn't take cases unless there's less than 2 months between these because they rarely win in court." That's a bold statement. Is my case with the EEOC doomed for this reason? And is there anything I can do to strengthen my case with this potentially weak temporal proximity? What should my strategy be going to my initial interview with the investigator? Thanks. All right. This Unusual World, in my opinion, just my opinion, I wasn't in the room when this attorney said this to you, nor was I wearing my very strange vampire outfit. But that attorney is really telling you that she or he only wants super easy retaliation cases. And I think that is very foolish on that attorney's part. 2 months, listen, 2 months or less is a great temporal proximity. I agree with this attorney about that. The idea that you would only take cases with a 2-month temporal proximity strikes me as ridiculous. And I say that as someone working at a firm where we where we have our cough out of control. Let me get some water. I say this as someone who works at a firm where we cover the expenses for our clients. So we are very much putting our money where our mouth is when we say, yes, we'll take a case. And I will tell you right off the bat, I don't get shy about retaliation until about 3 years. 3 years is when I start to say, I don't know, that's pretty long. And even if you go past 3 years, if there's some logic, like the person you complained about became more powerful in year 4, and that's when the person that you complained about acted against you, retaliated against you, that's a good narrative. I can work with that narrative, right? So like the idea, 2 months or less, no. It's okay. Listen, attorneys are free to take whatever cases they want to take. And listen, that attorney might even be telling you or acting on the thought process that she or he is only really capable of winning cases with tight temporal proximity. That's fine. That's their right. That's their choice, right? I'm not going to fault that person. But I will say, I strenuously disagree. I think many other attorneys would disagree as well. Next question. Choose Compassion says, hello, Vince and chat. Hello, Choose Compassion. Sean S. says, good afternoon, everyone. Good afternoon, Vince. Good afternoon, Sean S. Norma Deplume says, yay, happy Halloween. It's scary at my job. I believe that very much. Sean S. says, expect Vince to be in character. Vince is in character. Vince does not have his porcelain fangs yet, but I got myself some porcelain fangs because nobody's going to know I'm a vampire with this thing. This literally is a vampire coat is the costume. Like it's how it's labeled. Nobody knows that's a vampire. It's just like I look like a Victorian, maybe not Victorian. I don't know what era. Like lazy noble, right? VA says, hi, Vince. Happy Halloween. Happy Halloween to you. I watched your video this morning about pitching a retaliation case to an attorney. My question is, have you ever experienced an employer using layoffs due to budget reasons as a pretext for terminating someone who filed a discrimination case at an organization? How do you handle it? So, yes, one of the most common things in the world. And let me just clarify, it's not that I think it's common for an employer to schedule a layoff, a RIF, a reduction in force, because they want to get rid of someone. I think what happens is that a RIF gets scheduled, and then the employer looks at the person who complained and engaged in protected activity and says, let's get this person in that RIF. Let's get this person out of here under the cover of the reduction in force, the layoffs, right? And that is a clever move on their part. Now, there's things you can do, like look at the metrics for who was put into the RIF and how that was decided, and differentiate your client out, right? There's a lot you can do there. It's going to be detail driven to your situation, very unique to your situation, but nevertheless, something you can deal with. Lucky 7 says, do you automatically win your case by default if the employer doesn't give a position statement? If you're talking about the EEOC, Lucky 7, you don't win anything besides a right to sue letter. They'll just give you a right to sue letter probably, and you go on to federal court. YouTube user Ramona Hudson says, does my EEOC attorney need to know any and everything about my workers' compensation mediation? Is it ethical? Okay, so Ramona, there's no reason, I think I made you a video about this. There's no reason that your attorney handling your EEOC matter and your attorney handling your workers' compensation matter should not collaborate and cooperate. Further, the attorney handling your EEOC wants to know about your workers' comp, because what the employer might try to do is get the workers' comp attorney to execute a general release, a release of all claims in the workers' comp case. Now, most comp attorneys are going to be very disinterested in doing that, but if they're not aware of the other case, or if they're not, in conversation with your EEOC attorney, they might sleep on it and have you execute a general release, which would grant a release of your EEOC claims, potentially. And so that's probably what your attorney wants to be on top of. Also, additionally, it's worth noting that in some workers' comp cases, the money you receive can offset your damages in the EEOC case. Because, listen, you can get economic damages in workers' comp, and I don't handle workers' comp, but I've certainly seen it happen. And you can also, in certain workers' comp situations, get emotional damages, which could offset the emotional damages in your EEOC claim. So there's a lot of reasons where your EEOC attorney is going to want to collaborate, cooperate, and communicate with this attorney handling your workers' comp case. YouTube user Anish says, is my case value low if the incident took place in 2022, but I can't get in front of a judge until 2026? No, that just means you're in a jurisdiction with a slow docket. Aaron R says, hey, Vince, happy Halloween. Happy Halloween, Aaron R. Insert promo here says, hi, Vince. The biggest issue in my case is proving constructive discharge. Is it relevant that my manager threatened me that if I needed formal accommodations, she makes sure I was fired? That is incredibly relevant. I think that is a tremendous boon and benefit and a wonderful piece of evidence, if you can prove it, to support your constructive discharge claim. Checking my email, because we're in the middle of the day. Checking my email. How many emails have we received? Okay. Back to the live stream. Next question. Lucky 7 says, and what's the max amount of time the employer has to provide a position statement? What happens if they never do? So there's really very little in terms of consequences if they never do. I don't know what the max amount of time is, because I can give you the max amount of time that they say, but that's not true, because they give employers extensions like 2, 3, 4 times routinely. So I don't know what the true max is, because it seems like they just give employers endless extensions. Atlanta Brandon says, Vince, if I am suing a company, do I serve the defense, the lawsuit first, or do I file it in court first? Okay, listen. Quick answer is you hire an attorney first and have somebody who knows how to do this handle it for you. But in most jurisdictions, everyone that I'm aware of, you file with court and you serve what is filed in court upon the defendant. Now, you need to check with local counsel. Local rules can be different. Sean S. says, sweating emoji. Holding up garlic while asking my question, because I'm a vampire, right? Garlic. Garlic is delicious, for the record. I grow some really cool varietals of garlic at my farm. What should I expect after I submit my rebuttal? Oh, Sean S. says he's also holding up a mirror, too, because vampires don't appear in mirrors. I, however, have a different reaction to mirrors, where I just start to preen and become obsessed with myself because I'm a narcissist. Sean S. goes on, what should I expect after I submit my rebuttal to the employer's rebuttal? I think you might mean your rebuttal to the employer's position statement. So after you submit that, there's going to be a period where the investigators might actually investigate. They might hold fact-finding conferences. They might try to get the case settled. And eventually, they might issue a right to sue letter, assuming we're talking about the EEOC. Norma de Plume says, Liberace, Matador, sexy. Why, Norma? My goodness. Norma, I'll direct you to my OnlyMans, which is a separate account. 100% kidding. I'm sorry. I am neither Liberace nor a Matador, although both of those guesses make a lot more sense given this coat. I am a vampire. I was advised that I must be a vampire this year. My fangs, I didn't put them on yet. They haven't come in. I mean, they arrived, but I haven't picked them up yet. Okay. YouTube user Corey says, can you explain why the time at your job matters from a year or 10 years? What's the big difference? Does it matter if it's he said, she said matters? All right, Corey. So I'm going to blow your mind, and I'm going to give you the answer that the rest of the industry feels is the correct answer. I don't think it does matter, or I think it matters very little. The idea that you have been sexually harassed or discriminated in the workplace, that can happen on day one of a job or day, I don't know, 10,000, right? So 10 years in, 1 year in, doesn't make a big difference to me. I am generally unconcerned with that logic. However, the industry as a whole tends to care. So the plaintiff side employment attorneys, when they look at cases, tend to really put a lot of weight on this, which I think is very foolish, but they do. Many of them do. And I think the logic is, well, you have a proven track record of success. Clearly, you can do the job. You've been there, 10 years, right? And I would say that is just nonsense, absolute nonsense. Like, yeah, I mean, I guess you've proven that you can do the job, but like, they hired you. Proving you can or can't do the job, or proving some kind of track record of success, or, that you're not having issues on the job. Like, how often do new hires get sexually harassed or sexually assaulted? How often do new hires experience discrimination right off the bat, right? Like, it just doesn't make sense to me, and I don't find this to be compelling as a logic for selecting cases. YouTube user Aaron R says, my employer wrote me up 2 weeks after going on to a modified duty because of a work injury. My attorney sent a letter stating that any additional retaliation would result in a discrimination charge. Great. Looks like your attorney is being very proactive. I love that. YouTube user Corey says, is a supervisor statement claiming I was being discriminated against good for me? Yes. But also said I was a problem, which one weighs more, the discrimination or me being called a problem. So, I mean, it could be either one, right? Also, though, just because you're a problem doesn't mean you weren't the victim of discrimination, right? So, like, how do I put this? I'm going to tell a story about a deceased gentleman. I'm not gonna identify him, but he was a pretty racist fella. He grew up in an area of the country where there's not a lot of African American people, and I'm going to tell you, he knew probably 6 African American people in the entirety of his career in his life. And he was a bit racist, but he liked all 6 of those men quite a bit. In fact, he counted several of them to be his friends, very much so. Like, to hang out with, to go out to breakfast with, like, go hunting with. Like, he liked these people. And he thought of them as the good ones, which is super wildly racist, right? And he would tell people, yeah, Jerry's, he's one of the good ones. Wildly racist. But here's the thing. Hypothetical Jerry, very likable. Very good at his job, right? So he didn't experience racism the way a more mediocre employee might, or a more abrasive employee might, right? So this older gentleman that we're discussing, he was racist, no question. I don't think he would be like, yeah, I'm racist, and I think that's the correct way to be, which is wild. But these 6 gentlemen he knew, whom he counted to, these 6 African-American gentlemen, whom he counted to be legitimate friends and good people, never experienced his racism because they were likable and good at their jobs. So the idea that being a problem somehow means that you weren't the victim of discrimination, I don't buy that at all. I, in fact, think a mediocre employee or a problematic employee is much, much more likely to experience discrimination in the workplace because the outsized response they will receive to their mediocrity will be driven by their membership in a protected class, right? Which is a very complex thing in this industry, right? Because there's this tension between like, no, they're just bad at the job. No, it's discrimination. Or it's both, and those things intertwine, and like the mediocrity at the job pushes the size of the discriminatory response. This is a very unpopular perspective. It's a complex perspective. It is also the most accurate perspective. There's no question, right? So the idea that like the supervisor said you were a problem, but also said you definitely experienced discrimination, I would just say that's a very perceptive supervisor. That supervisor is probably being incredibly honest and sincere, and is probably a little smarter than the average bear. Just my thought, Corey. And Corey, just to be clear, I'm not calling you a problem or mediocre or unlikable or abrasive or any of those things. I'm just kind of giving discussion. All right. CNO 1906 says, gotta blow my note. CNote 1906 says, hi, Vince. I'd go with Liberace, or the candelabra. I assume you mean the candelabra from Beauty and the Beast. Looking at myself in the camera right now, I can certainly see it. Yes, I think I am the candelabra. In fact, I may tell people that I am the candelabra. Anyway, we have court-ordered mediation. What is the mediation process like? Does there have to be an outcome? There does not have to be an outcome. You do not have to agree to a settlement. In terms of what the mediation process is like, we have a mediation preparation playlist, which contains, I think, like 30 videos. I just added to it this week in terms of a video of like what you should expect from your attorney before mediation. I would urge you, rather than ask me here, which is great, you can always ask me here. I'm not begrudging you asking me here. I'm just saying I have created 30 videos on this topic in a playlist, all of which are directly on topic, and I hope to be useful for you. And that would be far more valuable than what I can do in terms of answering your question in a live. Quick note, we have 33 active viewers, but only 10 likes. The likes are how the YouTube algorithm notices us. So if you like the stream, please click the likey like button. It helps us to be noticed by YouTube. Aaron R says, I was terminated 1.5 months later, and now I am in investigation. Does that letter create a strong case for me to receive a cause for finding? Yeah. Listen, the letter from a supervisor that says you experienced discrimination and also says you were a bit of a problem worker, I find that very compelling. I find that to be great evidence. I find that to be incredibly sincere evidence. Corey says, how long is the live today, sir? 1 hour. 1 hour. I have a variety of Halloween-based activities that I must attend to. So we have 1 hour, 2 p.m. to 3 p.m. Eastern time today. I will be driving to New Hampshire tomorrow. So I must do the live stream today instead of tomorrow. 22J-Dog says, Vince, looks like the Interview with the Vampire movie with Tom Cruise. Well, thank you. That is, I think, what we were going for. I think that's what was the goal. Savi Lot says, for a retaliation complaint, is it considered protected activity if you notified your employer that they've been out of compliance for not submitting EEO compliance reports when they have 2,400 EEs? Yeah, I think you could make an argument that's protected activity. I mean, listen, check with local counsel, but I would argue yes, that is a solid argument. YouTube user Nico Gomez. Chat jumped ahead on me. Nico Gomez says, I was wondering, have you heard of the Abercrombie & Fitch situation? You're going to have to narrow it down. My little brother was a model for Abercrombie & Fitch, I am told. And I wanted to bring up Does the situation, can it bring up possible cases that can be filed? Okay, I'm not sure I understand. Okay, so, and I wanted to bring up, does this situation bring up possible cases that can be filed today that happened in that time period? Like past racism and sexual coercion and not being given the position you originally applied for. Nico, if your claims are within the statute of limitations for the federal statute or the state statute or local law, you can bring it up, certainly. If you're not getting a position or a promotion because of some form of discrimination or sexual coercion, you can absolutely file that claim as long as it's still timely. There's some ways to extend statute of limitations, like the continuing violation doctrine. Or listen, New York had a statute that extended some, like sexual assault statute of limitations. There's situations, so in different jurisdictions and different circumstances, that can extend statute of limitations. It is rare but possible, and so you should check. I would urge you with local counsel about the specifics of your situation. YouTube user Shamika says, I have a workers' comp case and an STAA whistleblower case, federal and state. If I settle my wrongful termination for a workers' comp case first, will that affect my damages for the OSHA STAA whistleblower case? Shamika, it could, depending on what kind of damage you get. But also, you got to make sure that when you settle your workers' comp case, you have a carve-out for your other case, right? You don't want to sign a general release that releases all claims. You want to sign a directed release with a narrow band of things that it's releasing for the workers' comp case, because really, why is the workers' comp case releasing anything in its settlement besides the workers' comp case itself? And that would protect your OSHA case. Make sure your OSHA counsel reviews the settlement for the workers' comp case to ensure that you are protected and not giving up your rights. Checking emails. Okay, back to live stream. VA says EEOC advises against laying people off who have complained, if at all possible, right? Because laying them off is sus. Yes, I would agree. Laying them off is sus, but it also depends on the size of your reduction in force, right? If you have 10,000 employees and you're laying off 3,000, and in your company you have 100 employees who have engaged in protected activity, right? They've complained about discrimination or sexual harassment, and in that reduction of force of 3,000, so just shy of a 30-year workforce, you're including like 20 of the people who complained. The ratio is pretty good, right? You seem to almost be selecting fewer of the people who complained. So at that point, it does kind of undercut the retaliation claim for the RIF. And that is, listen, if I was trying to structure a RIF, a reduction in force for an employer who had a lot of employees who complained, I would probably urge them to keep that ratio pretty low. It might provide them some level of protection. But of course, I don't do defense work. So, you know. Norma de Plume says, does being fired while injured always mean it's an illegal firing? No. My company claims no. Removal is justified for bad attendance, but I was injured. So, yeah. All right. So, Norma, listen, there's a lot of circumstances where your injury does not protect you from being fired. You could use up all your time. You could be failing to cooperate or communicate with your employer. You could just be completely incapable of doing the job ever again, even with accommodations. There's certainly ways where you could still be fired. It's not an open and shut black and white thing. It is a context-driven analysis. But generally speaking, it is a red flag. If you're injured and you need accommodations or you need time and you're being terminated, I would urge you at that point, speak to 3 to 5 local employment attorneys and go over the specifics of your situation and make sure you're being well protected. VA says, definitely a young Liberace. Vince just needs a white piano. I did take 8 years of piano lessons, and I am not good, but I do enjoy playing the piano. I guess I'm just going to lean into the young Liberace thing, although, I mean, I'm in my 40s here. I don't know how young I am. Nico Gomez says, what if you have text of a manager asking you to come to their house to smoke and deal with sexual coercion, but you deleted your social media account that had the text of the invitation? Is that a possible claim? Well, Nico, listen, you can still testify that you received that text. I don't know if you can get it. Like if you can get that text or that instant message or whatever it is, you certainly want to get it because that's way more valuable, right? And listen, them ask you to come over to the house to smoke. It's not the most clear-cut thing because that could be non-sexual. That could be like as pals, as buddies, right? But it could also be, you mentioned there's a component of sexual coercion there. So if it's like an innuendo, or there's like an extra component to coming over to smoke, or like they're like, yeah, why don't you come over to smoke and chill? A little bit of Netflix and chill, right? Like there's things like clearly that could denote that like, hey, this is actually a sexual come on. And at that point, certainly whether you have the text or you need to recount it in your own testimony, that is a potential piece of evidence. YouTube user Storyboy says, love your channel. It's been a huge help and resource for me. Super glad to hear that. Making the channel feels silly and ridiculous talking into a camera like this. Like, I don't know how many of you do this, but like, I'm just alone in an office talking to a camera, and it's like, it's weird. It's a weird thing to do, right? And I just talking for an hour straight. Like I read what you write, but like I'm alone, right? From my perspective, like I'm just sitting here, right? So it feels weird. So saying it's helpful makes me happy and helps me keep doing it. Storyboy goes on. We are currently in the investigation phase of the EEOC and have received the employer's position statement. In the statement, their primary and only defense is that my complaint is not a protected activity. Got it. They point out that I do not specifically say due to my race in my complaint letter to the HR. Okay, is there more? My question is, how precise do we have to be in the wording of our complaint letters? Do I have to use specific wording or specific legal terms for my complaint to be considered a protected activity? Okay, so it is a form over substance analysis for this. If it sounds like you're talking about discrimination when you engage in protected activity, that will generally be good enough. Or if you can make an argument that the things you're complaining about specifically denote some form of discrimination or sexual harassment or something of the sort, then that's going to qualify as protected activity. If your complaint was like, they're mean to me, or I'm receiving generalized harassment, right? Like at that point, like that's probably not going to qualify in most jurisdictions, in most situations, as protected activity. But always get your specific protected activity, like discuss it with local counsel, get 3 to 5 consultations, really talk things out. Because, there's ways you can argue, like there's definitely cases where like because people don't want to play. This is the thing people say a lot. I didn't want to play the race card. Okay, that's another way of saying you didn't engage in protected activity correctly, and now our case is way weaker. So there's a lot of things you have to do to strengthen that case because our society really puts pressure on people who experience discrimination to not like call it what it is, which is discrimination. What's next? YouTube user Henry says, what if my doctor works for the former employer? Is that a conflict of interest? She was the provider attached to my medical records that are related to the claim. I mean, I would urge you to get those medical records ASAP into your custody, and also maybe start treating with a different doctor. I'm not questioning your doctor. I'm sure your doctor is great and honest and sincere and loyal. I just think that it might create a difficult situation. Or some perception of impropriety or pressure that you don't want to live with, right? Susie B says, a little bit of water here. Is transfer as retaliation hard to win? My attorney at the time said I had to wait for a recent court decision to give my constructive dismissal case strength. Unfortunately, missed the EEOC deadline. So the transfer as retaliation, if it isolates you or gives you gives you worse work conditions, that's a perfectly valid negative workplace consequence for the purposes of retaliation. I'm fine with that. I don't think you need to wait to file that. However, I take issue with the second part of what you said. Well, maybe not. So they waited for a court decision to give your constructive dismissal case strength, missing your EEOC deadline. Yeah, that's weird to me. That doesn't make a lot of sense, but I would urge you maybe talk to a different attorney and check your local and state law statutes and limitations so that you still have those claims and you can still pursue this case. Zavilat says, Vincent, try a neti pot for your sinus and cough or my purist. Okay, I'll look into that. Thank you. NYC Damages says, hi, Vince. Thanks for being live again. It's my pleasure. I love being live. I hope I help people. In an EEOC right to sue letter, is an EEOC right to sue letter always sent via mail as well as the portal, or only in the portal? So I have seen situations where it was not sent by mail or not sent by mail correctly, or the postal service may have like swallowed it up. This often creates a lot of litigation. And also, sometimes you have to go out to the EEOC. Sometimes you have to, there's a lot, because you don't want to lose those federal claims. So what I'll say is I think it's always a mistake somewhere along the chain when the letter is not sent via mail as well. However, it does happen. Ooh, this is clever, Sean S. Diary of a Vince Pyre. That's right. I'm a Vince Pyre. When defense counsel uses more than one attorney, they always do, a principal and an associate, is that a good sign for the plaintiff? No, I think it's generally pretty common. Remember that they're billing by the hour. So if they've got two attorneys assigned to the case, they're going to be able to do more work, which is good for the case and good for their client, but also cost their client a lot more. So generally there's going to be at least two attorneys in my experience. Often you'll see 3 or 4. Corey asked, is it malice if I asked a Hispanic supervisor why the younger Hispanic don't get on to the older Hispanic? He said it is a sign of respect, then wrote an email that was not true and got me fired. Do you know the statute of limitations for sex trafficking in New York City? And the separate questions here. Corey, I mean, is it malice? Corey, I'm going to be honest. I don't know the answer to that question. I don't think I fully understand that question. And I don't know what you're asking. I'm sorry. Nico Gomez says, do you know the statute of limitations for sex trafficking in New York City? I do not. And sexual coercion? Well, sexual coercion in the workplace in terms of like quid pro quo or like stuff like you can keep your job if you sleep with me or if you flirt with me, or like I'll give you a promotion if you sleep with me or flirt with me, or like all these things. That's 3 years in New York under the New York City and New York State human rights laws. Corey asks, can I ask for money and my job back? Just want to know, would love to see their faces after winning a big lump sum after being done wrong. Corey, I mean, I could see that as a basis of a claim. I'm not entirely sure that I understood. I mean, it sounds like you were asking racial questions in that scenario. So I'm not entirely sure I understand the claim, but it could be a claim. All right, next question. Quest Hypu 305 says, hello, friend. Hello, Quest Hypu. 2 questions. Seattle has something called declaratory judgment. Someone had success getting one, and it strengthens their employment claim. Any thoughts? Can you elaborate on this? No, I mean, declaratory judgment exists in a lot of places, and I can certainly see how it might benefit an employment case, but I can't speak to Seattle's. I'm not allowed to speak to the state laws of other jurisdictions that I'm not admitted in. That's why most of my answers stick very tightly to the laws that pen through the EEOC under the federal government. DeAndre Stinson says, in a defense-based act claim, how long does an OALJ have to respond to a motion for summary judgment? Defense or the employer has not filed a counter motion, and it's been 3 weeks. So generally speaking, if you file a motion for summary judgment, it sounds like you're the one filing a motion for summary judgment. The other side will get a set amount of time. They'll be given a deadline to file their opposition. Don't know if they've been giving a deadline yet. So it sounds like that conference might still be coming for someone to assign them a deadline. And just to be clear, I'm speaking generalities here. I'm not speaking into any particular jurisdiction or the procedure rules. You got to check with local counsel for that. But generally, when you file a summary judgment motion, like you're seeking summary judgment, the judge, the magistrate, somebody will set a deadline for the opposition papers, the opposition to the summary judgment motion to be filed by. And there might also be a response, a rebuttal to the opposition papers to their summary judgment. And then the judge, depending on the jurisdiction, could take anywhere from 6 to 18 months to make a decision on that summary judgment motion. Often it is quicker, but it can take quite a while. Quest Haipu 305 says, number 2, can you tell us of a time you did or filed something unexpected by counsel to spice up the court life? LOL. Sure. I mean, it's pretty well documented. In the press, we had a sitting judge in New York, act allegedly very inappropriately on a case. And we had to, we filed with the state to initiate an investigation. And that judge, rather than being investigated by the state, removed herself from the bench, retiring. So that was an unexpectedly aggressive move by us that people thought was very foolish on my part and kind of like irrationally aggressive. And then it went really, really well. And it certainly gave me a great deal of agita and concern, but it was the right thing to do, and it's what we did. Mr. Cato ASMR says, Vincent, why did opposing counsel cancel the deposition a week before? Because they had a schedule change. It wasn't convenient for someone. They think the case might settle, so they don't want to do a deposition. There's a million reasons. I don't know, Mr. Cato. I'm sorry. Natural Intellectual. If I settle, can I negotiate signing an NDA? Sure. I don't know if they'll agree to negotiate, but you certainly can try. I would like to speak about my experience with a large financial company, possibly even starting a YouTube channel about my experience. Yeah, listen, I don't know if they'll agree to the settlement without an NDA, but certainly people can negotiate that. It's a term that you can go back and forth about. In some jurisdictions, you actually can't be forced to sign an NDA very easily right now. It's like California. So yes, you absolutely can. Corey says, after I sent my rebuttal, what's the next step? They investigate. How long before I know if I'll get my right to sue letter or be letting the EEOC take charge or get an attorney? So anywhere from 4 months to 3 years with the EEOC. That's how long you'll find out. Zavi Lot says, thank you for these live sessions, Zavi. I'm super happy to do them. I love them. The Trauma Center, a place for healing, says, is there any real benefit in choosing an EEOC hearing process versus choosing federal court? Also, can you file in state court if you are a federal employee? I don't think that you can file workplace discrimination or workplace sexual harassment claims in state court as a federal employee, at least to my knowledge, but I don't want to speak out of turn on that. There could be laws that allow you to in certain jurisdictions, although I think that's highly unlikely. I would choose federal court 100% of the time as a federal employee. I appreciate you too, Corey. I hope my answer was responsive. Crispy Badger. Hi, Vince. That's a great username. Crispy Badger. Badger. Hi, Vince. If I successfully win a pro se federal employee EEO case on appeal, can I then hire an attorney to help me during the damages phase? Sure. Why not? What kinds of payment arrangement options would there be? That I don't know. It's going to be whatever you work out with the attorney. I mean, most of the time, you would either pay them hourly, you'd pay them a flat fee, or you'd pay them some percentage of whatever they win for you, or there's hybrid retainers that mix the three of those up a little bit, right? Any two of those or any three of those. Okay, checking emails to make sure there's no fires, the world is not burning. Okay. Okay. Okay, what do we got? Next question. Sabi Lot says, after receiving a right to sue letter, can the employer agree to mediate and then change their mind about mediation during the mediation? What happens if that's the case? well, your mediation ends. And you then would choose to go on to federal court or not, or where you want to file your case next, right? Mediation, when it's voluntary, is entirely voluntary. They can choose to engage the same way you can, or they can choose not to, or they can end their involvement. They can end the mediation at any time. It's completely and entirely voluntary. Okay. Bum, 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 bum. NYC Damages says, how do you use what other employees tell you that you can't prove yet if you are in or before the negotiation phase in the EEOC? Can you use similar harm or harm based on the same basis? How far back in history can you go with this formerly fired employee? Okay, so I think what you're saying is like, listen, I've got a case where a thing happened to me, like some kind of discrimination or sexual harassment was done to me, and I know similar things have been done to other employees. Now, that's not the best evidence of proving what happened to you, but it does have some evidentiary value if you can show a pattern, right? Like, hey, they got a pattern of doing this. And listen, I would say you can go as far back as the players are the same, right? Like if a company has the same people in the same places and there's a pattern that you can extend back 10 years, then I would extend back 10 years. And if the court stops you, then that's fine. But, like, listen, if you can show a 10-year pattern of practice and it's the same people involved in the case at hand, I think that has value. It doesn't act as direct evidence of what happened to you, but it is, listen, it's a form of circumstantial evidence establishing that this often happens, and that's beneficial to you because you're saying it happened and you can show that it often happens, and that means it supports your narrative, right? Insert promo here. Employer discussed severance pay in a meeting followed the same day suspension is first warning. Constructive discharge? I mean, yeah, I think you can make a decent constructive discharge argument there. It's not open and shut, but it's some for sure. YouTube user Case says, hey, Vince, I'm pro se. Submitted my rebuttal 4 months ago. Followed up with the investigator 2 months ago. She stated to be patient and it's under active investigation. Should I keep following up? How often? Every 2 months, I think is pretty reasonable. I think that's a pretty reasonable amount of time to follow up. YouTube user Guy says, hello, how can you prove racism discrimination despite the obvious being the only other culture in the department? I am currently in talks with HR. Of course, the cover-up begins. Thank you. Okay, Guy, so you would take any piece of evidence, anything you have that you think shows that you were treated negatively on the basis of your membership in a protected class. That's it. I know it's not like a satisfying answer, but like, I can't tell you all the ways that you could prove discrimination. The better approach is to look at your situation and say, okay, how would I show someone, given the things at my disposal, that I was treated differently on the basis of my protected class? Or here, race, right? You're very specific about race. So like, one, I'm the only person of a different race in this department. People, or if there's other people of that same race in this department, the people of that race are being treated differently, and we can demonstrate it in terms of the rate of promotion, the rate of termination, the rate of getting raises, the rate of discipline, right? The way that we're talked to, the job duties we receive. Sometimes certain groups, like a certain race, will receive like more difficult job duties, more physically demanding job duties. It's hotter in there. It's uncomfortable in the room they work, right? There's worse chairs, worse working condition, right? There's a million. It's going to be a situation where you have to figure out in your specific context, how can we demonstrate that race was a motivating factor in people being treated worse, right? A. Watkins says, the EEOC has filed suit on my behalf. That's amazing. Should I get my own attorney? I would. Also, what are the chances that this settles without going all the way to trial at this point? Generally, about 98%. In the field as a whole, it's about 98% settlement rate based on the statistics I've seen. Okay. Whoa, chat jumped ahead on me. YouTube user Shamika says, for my STAA whistleblower case, I first reported the federal violations verbally to my manager, and then a written summary to my HR manager. Also submitted a complaint to federal agencies. There was no investigation done, and I was terminated for attendance, but never written up. And the day they said I was late, I have proof that I was there early, and I was terminated days later, and the company doesn't terminate employees for being late. That sounds like a pretext. Certainly sounds like retaliation to me, Shamika. Natural intellectual disclaimer. This is not my situation. Employer does not have a telework policy. Oh, got a stiff neck. An employer does not have a telework policy or a mandatory camera usage policy. An employee was asked to put her camera on, and she was in the tub. Can she sue? I mean, what? Why was she in the tub if she was supposed to be working? I mean, did they know she was in the tub and they were trying to get... Listen, if they knew she was in the tub, I guess, I don't know if it's... I guess you say it's a she, right? So if they knew she was in the tub and they're trying to get her to turn the camera on, that's sexual harassment. But if they didn't know she was in the tub, and frankly, how would they? Because what kind of asshole would be working remotely from the tub? There's nothing wild about being like, hey, can you put your camera on? Especially if you're being weird or not really doing work or like generally sucking at your job. Like this, the way people abuse telework is the reason why we're losing it, and we're losing the battle for telework right now. So like, I'm kind of the stance that like that person teleworking from the tub, unless the tub is an accommodation for some kind of disability or something like that, I kind of think she might be an asshole. And I don't know that I see a case there, but it's just my thought, just a hot take. Haven't thought through the situation completely, but the way you say it there kind of makes the person in the bathtub during working hours seem like a bit of a jerk. Norma DePlume says, love your lawyer day is tomorrow. Oh, that's so kind. Oh my gosh. Love your lawyer day is tomorrow. I sent 4 gifts preceded by emails. So they weren't nervous getting packaged in the mail. I love you too. I love you too, Vampire Vince. Well, thank you so much. I hope you didn't send us gifts. We do not accept gifts, but that's very kind of you. Thank you so much. Thank you all very much, by the way, for giving this stream 28 likes. I very much appreciate that. That helps the algorithm find us. And I'm glad, Norma, that you were sending your lawyer gifts. That's really sweet. A. Watkins says, how do I get the articles written about my case that state my name off the internet? Good luck. Getting stuff off the internet takes an act of God or Congress, in my experience. YouTube user Shamika says, investigation done, and I was terminated for attendance, but never written up. Oh, okay, I think we already read this. NYC Damages said, can you go after an attorney in some kind of way? They purposely made you wait, so you missed the EEOC statute of limitations. So if they were your representative and you hired them to file the EEOC and they did not meet that statute of limitations and they did not file by the required by deadline, then yeah, I think there's a malpractice claim there. You can certainly pursue them. I think you can also grieve them. I think there's a lot of things you can do. YouTube user Corey says, what would be a few things, by the way, 10 minutes left, 10 minutes left. What would be a few things you notice defense attorneys do not pay out or get due to defense attorneys do to not pay out or get claims dismissed? Well, they try to disprove the claim, right? They try to make the claim look ridiculous. YouTube user VA says, I love you for making the point about the problem employee can still have his or her civil rights violated. Yeah, I mean, listen, VA, that's just the reality, right? Like it's the same thing. It's not just discrimination, right? Like people will try to like attack flirtatious women. Like, she's asking for it. Yeah, no, that's not how that works, right? Like, should the woman be flirtatious in the workplace? No, it's inappropriate. That's not good, right? But also that doesn't mean you can then demand sexual gratification from her if she wants a promotion or she wants to keep her job, right? It doesn't, right? So like, there's these like complex narratives in this field where people don't want to like acknowledge that there's a tension, right? Also, frankly, for sexual harassment, like a model employee, a perfect employee, is less likely to receive sexual harassment because they will be often viewed as a valued asset or someone who's very safe in the company or someone who is on really good terms with management and so protected. But problematic employees who might, supervisors, mid-level managers might view as like, this person might need my protection, is way more likely to receive like sexual coercion or sexual harassment. And will be assumptions made like, oh, she can't complain. He can't go to management. They're already on the ropes. They need me. They got to give in to me if they want to keep this job. Or if they want to get ahead, they're going to have to give me what I want. And like, that's just a reality. It's a scary reality because people don't want to take those cases. Certainly, I don't feel that way. But they're just more complex cases. They're more complex narratives that take more work, right? More education, more arguing, more persuasion. Norma de Plume says, how do I prove my boss's previous EEO settlements of victims who won't give statements? Well, I'd file a FOIA request. Get them the Freedom of Information Act from the prior cases from the EEOC. Corey, so if a claim settles 98% of the time, how much does that lean in our favor? Well, Corey, I guess that depends on how much you want a settlement. It's a pretty good ratio if you want to settle your case. Although there's always the question of what are you settling for? Are you getting as much as you want? Are you properly hedging for risk? Like there's a lot to talk about there, right? NYC Damages says, if the EEOC files suit on someone's behalf and you hire an attorney, would the attorney cooperate with the EEOC attorneys? Yes. Does the EEOC share in the percentage or are they hourly once the EEOC files on your behalf? The EEOC does not take a percentage when they represent you. They are just paid by taxes. And your terms with your attorney are whatever you work out. Gray X. I have a gray X. No, I know what that means. The person hates the sun. I'm just kidding. I have no idea what this means. I have a mediation for sexual harassment, retaliation, toxic work environment, etc. What should I expect? I'm the victim, male. I do have an employment lawsuit and a workers' compensation suit against them. All right, Gray X. I have an entire mediation preparation playlist. It will tell you extensively over the course of around 30 videos what to expect in a mediation, how to prepare for mediation, what to expect from your attorney for mediation. It is extensive and far more extensive than what I can provide you here. So I would direct you to that mediation preparation playlist. I think that is the best possible thing for you. Mohammed Irfan says, if the employer doesn't give the social security number, half tax and W-2 to employers, what should he do? Please let me know. If you're not receiving your W-2, you should contact the federal and state taxation authorities wherever you are. That is the best thing to do. Insert promo here says, tell her where it gets crazy. They do hire large groups and fire due to business needs, and strictly enforced metrics can be difficult to manage, but I always loved helping my patients and customers. I get that. And to your point, insert promo here goes on to say, never from the tub, though. Mike Wolf says, can a plaintiff include individual perpetrators from the defense in their lawsuits of an EEOC investigation? Multiple members of the senior management were involved and implicated in my charge. Mike Wolf, if you are in federal court and you have your right to sue letter and you filed your claims for workplace discrimination or workplace sexual harassment, there are situations where you can add individual defendants, individual bad actors who work for the employer, the defendant. And that is something you can do in certain situations that could have tactical value, although it is generally not that valuable. It is something we do sometimes when we think it has value. And Mike Wolf, we often do that as a divide and conquer strategy, which can have some value for our clients. Corey, remember, everyone works, not everyone wins. That is wise words, Corey. Everybody works, but not everybody wins. You need to trademark that and sell merchandise. I think we do sell merchandise. I think we have like mugs, and I have a sweatshirt and a tank top and a mug that I think we sell merch down below. I'm not telling you to buy the merch. Frankly, I think buying the merch is a little dicey because like somebody bought the mugs, I think, and like had the mug on their desk. and their employer like freaked out about it because they didn't like. It's a little aggressive. The employer viewed it as like a pro-employee, like aggressive maneuver. So I'm not sure I'd advise you to do that. All right. K-Dog says, hey, Vince, great channel videos. Thank you, K-Dog. When filing an SEC OSHA whistleblower case, do they interact at all? Any thoughts, experience with these? Was retaliated against for raising illegal activity 9 days prior. So the SEC and OSHA, in my experience, do not collaborate very much. And if you need them to collaborate on something, I would probably urge you to like make the communication happen yourself. Like take information from the SEC to the other agency or vice versa, like, and like notify the investigator specifically of the information you want them to know. Oh, Choose Compassion. Thank you so much for putting my video links in the chat. That's so helpful. You are a wonderful moderator for our channel, and we owe you a debt of gratitude. Sean S. says, thank you for your time and answers, Vince. Have a great and safe Halloween. You too, Sean S. We got 2 minutes left. Probably our last question here. NYC damages. If the EEOC, after over a year, changes the investigator, and this is someone without experience, denies discrimination, claims based on some ridiculous logic, how do you not offend them, but get them to learn the craft? I know a federal worker, but still. Just take the right to sue letter, go to federal court. You're not going to change a federal employee, in my experience. It's just, the bummer of it is you're not going to change a federal employee. You got to just be like, okay, so like now I can go to federal court. I get a jury. I've got my right to sue letter. You know, it is what it is. Corey, I will not party too hard. Thank you very much. I have a table at a rooftop bar tonight, but I will not be the one running up my tab, I assure you. Tara McKee, last question of the day. Tara McKee says, federal employee, discriminatory and retaliatory termination, appealing to the MSPB, seeking reinstatement, but the agency is against it. The EEOC is in investigation stage, seeking attorney. Any suggestions? Listen, check your local options first. There's also a big knot of federal employee attorneys around DC. The office of Jonathan Bell is a good option. We do also represent federal employees, but we are wildly expensive to do so, just heads up. So, I mean, you're welcome to contact us, but I urge you to check all of your options first. Someone recently told me the office of Jonathan Bell is not currently taking cases anymore. I checked with them, and I don't know if that's true. So I think they're great for federal employees, among the best in the business. Yeah. Okay. Everybody, wonderful live chat. I love chatting with you. I'm going to try to do again next week. I hope all is well. I wish you all the best. I hope you're all getting paid big checks for these lawsuits. I hope that you're made whole or being treated well and you don't have a lawsuit at all. That'd be even better. I hope this was useful. If it was, like, subscribe, comment down below. It helps our channel to grow. Take care, everybody. Happy Halloween if you celebrate. Take care.